Good afternoon, everyone. We're getting ready to start, and we'll just give it a couple more minutes for people to join. Thank you so much for being here. Okay, Robert, are we ready to get started?
Yep, go ahead.
Great. Thank you so much for joining us today. We at Legal Services have been hearing many questions around family law, custody, and safety from both survivors of domestic violence and advocates. Survivors are facing unique challenges during this pandemic. We want you to know that you're not alone.
Today we're going to be talking about some family law concerns and challenges. With the courts closed for the most part, we're having to do things differently, and it's been a real challenge to figure out how things are working for judges, for attorneys, and especially for people who have cases. A few things before we get started. The information we will discuss is specific to Missouri, particularly the 4 counties we work in: St. Louis City, St. Louis County, St. Charles, and Jefferson County. Also, as you know, information keeps changing, so please check with your local court for updated information. Most importantly, what we're discussing here should not be considered legal advice, and we cannot answer your personal legal questions, but we do invite you to ask general questions in the chat box, and our team will do their best to answer those as we go. We will also respond to some questions at the end of the presentation. Now, before we get to the questions, let's introduce ourselves. My name is Robert Bodeker, and I'm an attorney.
My name is Laura Halfman-Morris, and I'm a social worker. And we both work in the Lasting Solutions Family Law Unit at Legal Services of Eastern Missouri. Legal Services offers free civil legal assistance in a variety of different areas. In our department, Lasting Solutions specifically works with survivors of domestic and sexual violence in order of protection, divorce, and custody cases. The questions we're going to talk about today are the ones we've received directly from the community. So, Robert, we are hearing a lot of questions about orders of protection. So let's start there. First of all, is it even possible to get an order of protection?
Yes, you can still get an order of protection, or what some people call a restraining order or an ex parte. Right? Courts are giving priority to these orders. In all of the courts around here, you can still file petitions at the courthouse just like before. But before they let you in, though, probably you'll be screened for coronavirus, checking your temperature and asking health questions. In addition to filing at the courthouse in St. Louis County, there's another option. You can complete and submit the petition for an order of protection online on their website. That's available during business hours. And we have a link to St. Louis County Courthouse's website where you can watch a video that will walk you through this process. A third option is that outside of business hours, you may be able to file at a local police station, but this may only be an option in St. Louis City and in St. Louis County, though.
That's good to know that victims can still file for an order of protection, and they have a few different ways to do that. So what happens after someone files?
Well, the judge will do one of 3 things after you file for an order of protection. First, in rare cases, the judge will just outright deny the order completely if they believe your petition does not meet the statutory requirements. When that happens, there's no temporary order and there's no future court date. More commonly, though, the judge will schedule a hearing and issue a notice of hearing or a summons. That's just a court date and a chance for both parties to tell their side of the story. At that hearing, the judge will determine whether or not to grant a full order of protection. In the third scenario, the judge may think your situation is so dangerous that a temporary order needs to be issued. until your hearing date. So you would get both a court date for the full hearing as well as a temporary order, the ex parte. When you file at the courthouse, most people will wait until the judge makes that decision, and then they will get a copy of the paperwork before they leave. In St. Louis County, if you file for an order of protection online, though, you should receive your paperwork by email. And if you filed at a police station, the paperwork should be faxed to you there. The respondent, that's the person who you are filing against, should be served with either the notice of the hearing or the ex parte order of protection and the hearing date. They have to be served at least 3 days before your court date, or else the hearing usually will need to be continued.
Good to know. Now, during this time of COVID-19, what does enforcement of order of protection look like?
Well, the judge could issue a put out order, which is when an order of protection forces someone to move out. Normally, sheriffs make them move out when they serve the paperwork on them. During the crisis, sheriffs have been authorized to put people out, and our understanding is that they're still doing this despite the virus. The court can also enter other orders for safety, custody orders, and support orders. And these orders will be on the first page of an ex parte. If any of these orders are violated, the police are still enforcing them by making arrests and filing charges. They may need to see your paperwork when they arrive, so try to keep a copy on you at all times. If you receive a full order and the respondent violates it, you can call the police and show them your order. These phone calls can be hard, but showing the order of protection might help law enforcement understand the situation better. In St. Louis County, the court is still accepting motions for contempt and holding contempt hearings. That's the only county in our area with a specific program for violations. In other counties, you could still try to file a motion for contempt and see if it will get scheduled for hearing. So those are some of the basics of orders of protection. Laura, from a social work perspective, what should someone do if they're fearful of an abusive partner?
Well, you have options. Filing an order of protection could be a helpful tool and is available to you. However, for some people with an abusive partner, it's not safe to do so. An order of protection is a court order, but it is also just a piece of paper, relying on you, the police, and the courts for enforcement. Because every situation is so different, we encourage you to talk to an advocate about what are the best ways for you to reduce risk right now. In the St. Louis region, we have several local hotlines, two which we pulled up here, Safe Connections and Alive. They are staffed 24 hours a day, 7 days a week, and are available to answer your questions. Also, an option is calling the National Domestic Violence Hotline. They have a 1-800 number there listed. Also on their website, thehotline.org, they have a lot of really helpful materials to help you brainstorm ways that you can stay safe. They also have a text line that's available. Now, Robert, now that we've covered some information on orders of protection, let's talk about custody. With the state and many counties issuing stay-at-home orders, there are a lot of questions on this topic. So first, can a parent travel to exchange their child with the other parent during Missouri's statewide stay-at-home order?
Yes, you may travel however you need to in order to follow your custody order. Court orders for custody and visitation remain in effect and are expected to be followed. Parents can agree to make changes to the plan though, but any changes ideally should be in writing. If it is unsafe to travel under your current custody order and the other parent will not agree to a change, you may need to talk with your lawyer about asking the court for a temporary restraining order or a motion to modify.
What do judges think about sharing child custody during this pandemic?
The courts are hoping that everyone's going to work through these times in a way that keeps everyone safe, especially children. But they also want people to keep following their orders and the orders issued by state and local authorities, such as social distancing and avoiding playgrounds and so on. They do understand it may be difficult to follow your regular custody plan during the pandemic. When it is dangerous or impossible to comply with the custody plan, parents are encouraged to make other arrangements, such as getting an agreement with the other parent to do something differently, offering to switch to Skype or FaceTime, or allowing makeup time for missed visits. If you have an attorney or a guardian ad litem working on your case, it would be best to talk with them about specific questions.
So, Robert, what happens if someone was supposed to do their exchange at court or if visits were at court?
If your visits or exchanges were at court, they should have reached out to you by now, but if not, you should contact them right away. It's our understanding that the Exchange Center in St. Louis County is not initiating any new cases, but they are continuing to work with the families they had before. If a visit is missed, try to be creative. You could suggest more FaceTime or Skype with the other parent, or finding an outside supervisor, if it's safe to do so.
Great. Here's another question we hear quite a bit. What are a parent's custody rights if there's no custody order?
Wow, if there's no order, first we look to see who's on the birth certificate. The parents named there are generally assumed to have the right to do whatever they think best with the child. Okay, but some rules of thumb. It may be a good idea to try to keep doing what you were doing as long as it's safe. If it's not safe, again, try to reach an agreement with the other parent and offer alternatives like FaceTime or makeup time. If the status quo has to change, you should talk with an attorney if you can, or be ready to answer to a judge if the other parent files a court case against you. You should be thinking about how you're going to answer these questions. Was the change reasonable? And was it in the child's best interest?
So, if there were no orders, could someone move away?
The same answer as before applies. Courts are trying to balance between the rights of a parent on a birth certificate to do what they would like versus the other parent's rights versus the child's best interest in having frequent and meaningful contact with both parents. Sometimes moving away can mean no more contact with the other parent, so this can be a hard thing to get a judge's approval for. Of all the things that might work, though, domestic violence could be one where a judge would agree with limiting contact, but there could also be ways to protect a person from abuse short of ending the abuser's contact with a child. Unfortunately, there's no easy answer here, so we would encourage people to talk with an attorney.
Sure. Robert, here's a difficult question that we receive frequently. What should someone do if their child is taken or if visits are being withheld?
There are three general actions someone can take. First, document your communication with the other parent and your attempts to communicate with them. If there is an order, you can call the police and ask them to enforce it, or go to the court and try to enforce that through a family access motion, a temporary restraining order, or a motion for contempt. Some of the courts are still hearing those if they're emergencies. If there is no order, you should think about beginning a court case right away. In any of these situations, we would encourage talking to an attorney, but we also know how hard that can be. The Missouri Supreme Court has all the forms a person without an attorney would need to file a family access motion or contempt case, but everyone recognizes these are challenging situations to deal with.
Absolutely. These are really difficult situations that survivors are facing. What about in pending cases when decisions have not been made?
If a case has begun, but there's no temporary order to keep things under control, the courts generally expect the status quo to continue. But there are certainly times when things have to change for safety reasons or health concerns. So I would go back to what I mentioned just now. Try to get an agreement. Document your communications or attempts to communicate. Try to find an attorney to get legal advice and be ready to justify yourself. Was it reasonable and in the child's best interest? Okay, so a lot of parents, including those in domestic violence situations, are having to continue custody exchanges during the pandemic. Laura, from a social worker perspective, what are some ways that you've been talking to folks about maintaining safety during exchanges?
And Robert, it's great that people are thinking about how to maintain safety. Exchanges can be a really stressful time and maybe more complicated during this pandemic, especially because kids are not going to school, and that's often where exchanges can happen. Here are a few suggestions from the National Domestic Violence Hotline, as well as our office, about ways that you can try to make exchanges safer. First, avoid exchanging custody at your home or your parents' home. We encourage you instead to meet in a safe public place. We often suggest a QT. Many are substations, they have cameras, and they're still open during this pandemic. Some people also find that meeting at a police station is a helpful place to try to keep the peace. Second, bring a friend or a relative with you to the exchanges, or maybe have them make the exchange. Think about bringing someone who would be helpful in keeping the peace, and not someone who might escalate tensions or emotions. If you have created a new plan that's not in the court order, make sure to have that plan in writing. That could be a text message, an email, or something on a messaging app like Talking Parents. Also, document how the exchange went. Sometimes writing these on a calendar can be particularly helpful. And this can just show any patterns that arise if things start not going well. And lastly, it's important to have an emotional safety plan as well. Figure out something to do before the exchange to calm any nerves you may be feeling, and something after to focus on yourself or your kids, like going to the park or doing a fun activity at home. Now, Robert, I did just mention making changes to a custody order. How could somebody do that if necessary?
There are a few ways you might be able to modify a custody order if you have to. If it is safe, discuss changes with the other parent and make any changes in writing. Obviously, this is ideal, but not always possible when there's been abuse and a power imbalance in the relationship. You can also file a motion to modify when the current custody order is no longer appropriate for the child, but that would need to be because of a major change that's going to last for a long time. To file your own motion, you can find more information on the Missouri Courts website, and that's at courts.mo.gov, or by going to your local court's website. We see a lot of people trying to change custody orders through orders of protection. However, judges actually may not be able to make changes to current custody orders in a protection case, and sometimes it can cause additional complications for custody cases. So we would encourage people to talk to an attorney.
We know finances are tight for a lot of people right now. What about child support? Should people still expect to receive previous child support orders?
Court orders remain in effect for child support, just like for maintenance or alimony or custody. This does not guarantee the payments will be received on time, though, especially with job losses and other difficulties. Nevertheless, unpaid support will continue to grow as a debt. There might be ways to collect the debt through the Family Support Division or with a lawyer's help. People can also make adjustments to child support through the courts and sometimes by agreement.
Now, beyond child custody orders, there are a lot of general family court questions. For example, will someone need to go to court for a conference in April 2020?
Probably not. The courts have stopped most in-person appearances until at least the beginning of May, which will likely be extended with the extension of the stay-at-home orders. Some courts may hear cases by video or phone conference calls, but this is case by case and varies by judge.
How are courts communicating these changes to court dates? What if somebody hasn't heard what's going on in their case?
The court will send information about a new court date and what technology they might use. Courts send this information to the address they have on file. You could also receive a call from the court or an attorney on the case, and these numbers often come up as anonymous or even spam likely. Make sure your phone is set up to receive voicemails and be sure to check them. If you think the court does not have your new address, you can call the court clerk with your information. We've got a slide up with the website for each court in our area. You can also write a letter to your division clerk. We know writing letters and getting a hold of someone by phone can be tricky, especially as courts are running with limited staff. If you do not receive a new court date before your current court date, though, you can check your case on the court's website, case.net. You would look up your case by your name or the case number. You can also, again, call the court clerk. Of course, if you have an attorney, email or call them.
Thanks, Robert. And CaseNet is such a helpful tool for all of us to keep up with what's going on with the courts. So now, what do virtual court conferences look like? How should someone prepare for that?
Oh, okay. This is new for everyone, and it's very different and very awkward. Often, if you're represented by an attorney, it will be a conference between the attorneys on the case and the judge. Sometimes the parties in the case are on the call, but they may be just on mute. Sometimes the parties just have to be available by phone for their attorney to call before, during, or after the conference. Some judges are holding full hearings where there's a court reporter, parties get sworn in, people are presenting evidence and testifying, but most cases are being continued. If you do have to appear, It's helpful to dress professionally, just like you're going to court. Go to a place in your house that is quiet and where you have privacy. We know this can be difficult. Just do your best.
Do your best. That's all we can do right now. This has been really helpful to talk about orders of protection, custody exchanges, and general family court questions. We also want to touch on important resources that are still available to people in need.
One great resource are advocates. Do you know of any advocates who can help survivors even during this time? And are there domestic violence shelters still open if someone needed a place to go?
Yes, absolutely. So there are advocates available 24 hours a day, 7 days a week, available to talk to survivors in need. We're pulling up here a list of the St. Louis area hotlines, including Safe Connections and Alive, the YWCA sexual assault hotline, Deaf Lead crisis line for folks who are deaf and also those who aren't, who would rather text somebody for help, and also the St. Louis Queer Plus support hotline, Squish. All of these and many more that we couldn't list on this slide are available for you to talk to someone for help. Also, it's good to know that all of our domestic violence shelters are still open, and they're taking special precautions to help keep their staff and residents safe and healthy. These 5 shelters are in the greater St. Louis area, and even if you just want to call again to help and for help and talk through what your options may be, they're a great resource. Further on the right side, there is the Alive Nights of Safety number. So if you are fleeing violence and you need a place to go tonight, and all of the shelters are full, you could call Alive. Sometimes with their Nights of Safety program, sometimes they can help somebody stay in a hotel room and cover the cost of that until the shelter space opens up. Next, we have a list of some helpful websites to go to. If it's safe for you to search online for these, we certainly encourage you to check this out. First is the St. Louis Ending Violence Against Women Network, or slavan.org. Not only is there a list of the many organizations that are working with survivors of domestic and sexual violence, you can also click on the COVID tab and learn what agencies are doing to provide services right now. Secondly, we have the St. Louis Family Violence Council. Again, there's a list of agencies in St. Louis City helping survivors. There's also a map of resources in the greater St. Louis region that you can click on go to DV resource map. And lastly, we list here the Missouri Coalition Against Domestic and Sexual Violence. MCA DSV is a great resource for all of us, but you can search for resources by county. So if you're not within the St. Louis region, go to that website and you can search what's available. I'll also say, Robert, that stay-at-home orders, while helpful in fighting COVID-19, can be challenging and even dangerous for people experiencing domestic violence. It is important to remember that even under these stay-at-home orders, you can leave your home to escape abuse. Also, advocates are available by phone and text to help you create a personalized safety plan. What is a safety plan? Simply put, it is a collection of individualized, practical ways to help you reduce risk and keep you safe. There's a space to talk about your emotions and your goals and what your next steps could be. Advocates can help you brainstorm all of the options available so that you can make the best choices for you during this very stressful time.
How can someone apply for help from Legal Services of Eastern Missouri?
I'm so glad you asked, Robert. There's a couple different ways that you can access us. First, you can go to the Legal Services website, lscm.org, and click Get Help Now, and you can actually start our intake process. Alternatively, you can call our main line, 314-534-4200. It's in the St. Louis area, or we have a free 1-800 number for outside of St. Louis. We're answering the phones 8:30 to 5 every weekday. We're here to help you with your family law issues and emergencies. And while we're working remotely, we are here for you.
Are there other legal resources aside from legal services?
There are. You know, and St. Louis is really lucky to have quite a few options available. First, we have the Missouri Bar's Free Legal Answers website, missouri.freelegalanswers.org. somebody can go to this website to get more information about lawyers who are volunteering to help answer family law questions. Also, our colleagues at the Crime Victim Center have a legal helpline open 9 to 4 every weekday, help especially tailored to help survivors of domestic and sexual violence. I'd like to mention too that St. Louis has several different places that can help offer free civil legal assistance, including the Catholic Legal Assistance Ministry, Arch City Defenders, the St. Louis University, and the Washington University's School of Law legal clinics. This is not an exhaustive list, but certainly places that survivors can go for more information and more help with legal advice. And Robert, I will add that we know survivors are facing a lot of other hurdles on things that we weren't able to cover today. These are really important issues, and we want to shout out the work of our colleagues that have been doing really helpful things on this. So if you go to our Legal Services Facebook page, you click on videos, you can get help on applying for food stamps, help with housing and evictions, and a video about how to get your stimulus check. These videos and topics are frequently coming out, so check back often for more information. Now, Robert, it looks like we have some time to take a few questions live that have been coming in through the comments. We do encourage you to keep asking questions. Our team will keep trying to answer those as they come in. But let's see, is there anything right now that we can answer? Let's see. Oh, here's a great one. What happens, Robert, if an abuser isn't served with the notice of order of protection hearing?
Great question. So if we've got a case that's already open and we've got an abuser who was attempted, or a respondent who has attempted to be served but hasn't been served yet, so the courts are probably going to continue the hearing probably for another 2 weeks, and then they're going to ask if there's a different address that could be used, and if you wanted to use a sheriff again, or if you wanted to have a special process server be appointed. That may be at your charge, though. The ex parte, if there were any that were issued, would be continued until that next one, so there's no lack in coverage. There are some times when there's too many attempts and the case is just drag on too long. Some judges will ask if the case should be dismissed. Some will just outright dismiss it. You could always refile, especially if you found where the person could be served.
Great. Here's another question that's come in, Robert. What happens if I am served as a respondent in an order of protection? What do I do?
Well, the first thing we would encourage you to do is follow the order as best you can. Talk with an attorney, make sure the court has your contact information, and make sure to appear at any hearings that are scheduled. If they are hearings where you anticipate the judge asking you questions, bring your evidence, bring the witnesses, or make them available, and you should do that from the first hearing.
Great. What's the difference between a TRO and a motion for contempt?
Okay, a TRO stands for a temporary restraining order, and that's an emergency hearing where a judge steps in and enters protective orders quickly, but then schedules a hearing a week or two later to see if that order needs to stay in place long term. The court may not allow you to file a TRO unless you have another case going on, or you may have to have just filed a case, like a motion to modify. Contempt is when a judge enforces an order they already entered. If you ask for a contempt hearing, what you're doing is you're telling the judge one of their orders is not being followed, and you're asking the judge to essentially punish the other person or get them to follow it.
Great. Thank you for all that information. Let's see, we maybe have time for just one more. What do I do if I get served with custody or a paternity case or a divorce case? What happens?
Well, you'll have 30 days from the date that you were served with the papers to file something with the court before the case can proceed. You should talk with an attorney if you can. You should make sure the court has your correct contact information. And again, you should be prepared to attend all hearings.
Great. We have one other question coming in that sounds pretty important that we want to just make sure we highlight. Robert, what would you tell somebody if they believe that a child is being abused or neglected?
Right. That's a really important issue right now, especially because children are so isolated. Normally, they're out in the community and they're interacting with people at school and people who are mandated reporters who are trained and required to call child abuse and neglect hotlines to report that abuse. With this isolation and the lack of exposure to those people, it's a dangerous time for kids in some senses. So there's a hotline through the Missouri Children's Division that you can call 24 hours a day. You would want to start there. 911 is also appropriate if you see something active and immediate. If it's a long-term situation or a situation that's just been building and maybe not urgent, speaking with a lawyer might be a good idea, or trying to find somebody in the community who has connections with with that family who might be able to step in and assist in some way.
Absolutely. And just to reemphasize, that hotline number is 1-800-329-3738. And if you're a parent and you believe your child's being abused, please give us a call. Again, our number is 314-524-43. I'm so sorry. 534-4200. That's 314-534-4200 to talk to one of our advocates. These have been really great questions. I think that's all we have time for right now, but please do keep asking in the comments or direct message legal services. We'd be happy to talk to you more. We just thank you so much for joining us today. It's been a pleasure to talk with you about this important issue. And while you see Robert and I on screen, it's truly been a team effort, and we want to thank those who made it possible, especially Jackie Matrisi, Sammy Horato, and Trill Rayford, who are helping answer questions. Also, thank you to the many legal services colleagues who helped offer technical guidance and support, especially the NBI team. We encourage you to check out our website for more information. Legal Services has a special COVID-19 page with updated information on a variety of different legal topics. It's very, very helpful. Also coming soon on our Lasting Solutions page, you're going to find a family law handbook, which outlines the topics we talked about today and more. Lastly, to anyone who might be tuned in and is struggling in an abusive relationship, please know that help is available. There are no easy answers, but there are folks who can walk with you on this journey. You will be believed and listened to. You can overcome this. Now, thank you all, and please be safe.